What stops a government from simply doing whatever it wants? One constitutional principle stands as the answer: the rule of law. It is not a single rule, it is a cluster of fundamental requirements that constrain power itself. Think of the rule of law as a hub with several spokes. Each spoke is a distinct but connected requirement. Together, they define what it means to live under law rather than arbitrary power. We will work through each spoke in turn, then pull back to see how they fit together. The first and most fundamental spoke is legality. It means that every exercise of public power must be authorized by law, whether by statute or by the common law. If a government official acts, there must be a legal rule that permits that act. The landmark illustration is Entick v. Carrington in 1765. The king's messengers broke into Entick's house under a general warrant. Lord Camden held that the warrant was void. There was no law authorizing it, and absence of legal prohibition was not enough. The state needs positive legal authority. The corollary is that individuals cannot be punished for conduct that was not unlawful at the time it occurred. Retrospective criminal punishment is a direct affront to legality. The second spoke is equality before the law. The same legal rules must apply to everyone, government officials and ordinary citizens alike. This is not merely aspirational. In MV Home Office, decided in 1994, the House of Lords held that a government minister could be found in contempt of court for breaching an injunction. The Crown and its ministers are subject to the courts just as any private individual would be. No one is above the law simply by virtue of holding office. Third is legal certainty. Law only constrains behavior if people can know what the law requires. This means the law must be accessible, publicly available, and sufficiently clear that those subject to it can foresee the consequences of their actions. Vague, obscure, or unpublished rules fail this requirement. Retrospective criminal legislation also undermines certainty because it punishes conduct that was lawful when carried out, making it impossible for the individual to have guided their behavior by the law. The fourth spoke is an independent judiciary. The rule of law requires that disputes about whether power has been lawfully exercised are resolved by courts free from executive pressure. If the executive could control the outcome of cases brought against it, legal constraints would be worthless. The Constitutional Reform Act 2005 placed judicial independence on a statutory footing. Section 3 imposes a duty on ministers, including the Lord Chancellor, to uphold the continued independence of the judiciary and to refrain from seeking to influence particular judicial decisions. Much of our modern understanding of the rule of law in England and Wales traces to Albert Venn Dicey's 1885 work, Introduction to the Study of the Law of the Constitution. Dicey identified three limbs. First, the absolute supremacy of regular law over arbitrary or wide discretionary power. Second, equality before the law, everyone, including officials, subject to the ordinary courts. Third, that the Constitution itself was the product of the ordinary law as declared by the courts, rather than a code imposed from above. Dicey's account has been enormously influential, but has also attracted sustained criticism. Critics argue he underestimated the legitimate role of executive discretion, ignored parliamentary sovereignty as a competing principle, and failed to account for the administrative state that grew through the 20th century. Finally, the rule of law has explicit statutory acknowledgement. Section 1 of the Constitutional Reform Act 2005 provides that the Act does not adversely affect the existing constitutional principle of the rule of law. The wording is deliberately conservative. Parliament is preserving the principle rather than codifying its content. What the rule of law actually requires is still developed by the courts and academic commentary. The provision nonetheless signals that the rule of law is a recognized constitutional principle of English law, not merely a political aspiration. Time to test yourself. A minister instructs a civil servant to act in a way that has no statutory and no common law basis. Which rule of law principle is most directly violated? Option A, legal certainty. Option B, legality. Option C, equality before the law. Option D, judicial independence. The answer is B, Legality. Legality requires a positive legal authority for every exercise of state power. Acting without any statutory or common law basis is the textbook breach of that principle, just as in Entick v. Carrington. The rule of law is not one idea, but a family of interlocking requirements, that power needs legal authority, that all persons are equal before the law, that law must be certain and accessible, and that courts must be independent. Dicey gave us the classic English formulation, and the Constitutional Reform Act 2005 confirms its status, but its detailed content continues to be worked out through case law and constitutional practice. Your modules, mapped to your uni, explainer videos for every topic, a tutor that knows your course, essay writer for your essays and graded, case briefs, flashcards, annotations, try it free for 7 days, link in the description,